Hello everyone and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court. And I hope today you're just having the best day ever. We are here with our continuing legal news roundup. All the legal news that you need to be aware of so that you might be better legally informed. We are beginning to win the culture war news. Some good news on the transgender surgery, hormone replacement, hormone botching, stuff that's going on. Some providers are dropping the so-called gender affirming care because of lawsuits. So the lawsuits are beginning to work. We have begun to cover some of these cases where people are suing because they were basically tricked into undergoing surgeries or undergoing chemical treatments or undergoing other things because they were in a state of confusion as they were young, and no one challenged them and no one did any sort of mental health evaluation. No one did any sort of mental health care. They just simply said, yep, you're a girl, you're a boy, because you say you are, and gave them the drugs and did the surgeries. And some people were like, you probably should have looked into that a little bit more. I was a child unable to consent. Well, some good news. Some of the providers have started to take notice of these lawsuits and are actually stopping some of the gender affirming care, let's call it, because, they don't want to get sued. So the lawsuits are working. The culture war is being won. Let's learn a little bit more about this. As Republican-led states have rushed to ban the treatments for the children's that lead to sterilization and other sort of barbarism, some families with the so-called transgender children had some kind of solace. At least they lived in states where they'd be allowed to receive those continued therapies. But in some places, including Missouri and North Dakota, the care has been abruptly halted because medical providers are wary of liability provisions in some of the laws. So the lawsuits are working. So it's like, yes, even in states where it's legal still to get these barbarous things that, sterilize children and otherwise, some of the people are like, okay, we're going to be sued. And so we're not offering the care anymore because we don't want to be sued very much. It's working. It's working. So even in states where it's legal, they can't get the treatment because they're noticing the lawsuits that are starting to be filed. It was a completely crushing blow, says Becky, whose 16-year-old son was receiving treatment at the Washington University Gender Center at the St. Louis Child's Hospital until they stopped cares for minors. Becky cried. Her son cried too. Well, the 16-year-old, not necessarily in a fully competent position to be able to make decisions for themselves because they're 16. The 16-year-olds can't get tattoos. The 16-year-olds can't do a lot of things. They can't sign up for the military. They can't drink. They can't do a lot of things because, they're kids. And some people are like, oh, maybe the kids also aren't competent to make these life-altering decisions. Becky's over here like, yes, my 16-year-old can do it. And the center is like, nah, we don't want to be sued very much because we can't help noticing the lawsuits are starting to file. Yeah. There was some anger there, not towards the doctors, not towards Washington University. Our anger is towards the politicians. They don't see our children. They say healthcare is harmful. Yes, it is. It is extremely harmful. That is exactly what they say. You got it. It is harmful. It is harmful. You're trying to chemically castrate or physically castrate children. It's harmful. It's reprehensible. It's barbarous. It's completely unacceptable. So yes, it's harmful. They don't know how much it helps my child. Helps their child or helps you. Is your child fully able to make this decision at 16? Do they really understand what's going on? We can't help noticing some of the lawsuits that are starting to be filed by the people who are like, yeah, they just put me on a train, choo-choo style, and they just, put me on a path with the gender transitioning chemicals, the chemical castration, the physical castration, removed my breasts, did other things that permanently harmed me when I was 13, 14, 15, 16, and didn't fully understand what was going on. No one did a mental health evaluation. No one challenged my mental health. I was going through a lot mentally at the time, and everyone's just like, give them the drugs, give them the surgery. No need to look into their mental health at all. So yeah, maybe, maybe another cause of pause. Since last year, conservative lawmakers, those bastards, and governors have prioritized restricting access to the transgender mutilization under the name of protecting children. Yep, that's exactly what we're trying to do. You got it, right? These people are under the age of 18. These people are not adults. These people are not able to get tattoos. They're not able to drink. They're not able to join the military. They're not able to get married in many cases, depending on their age. But, we're going to have them undergo these massive lifelong consequences with permanent surgeries, that can't be reversed, can't ever be fixed. Yeah, we're trying to protect the children. That's exactly what we're trying to do. At least 22 states have now enacted laws restricting or banning the genital mutilation of children and the other gender-affirming care for the so-called transgender minors. Most of the bans face legal challenge, and enforcements on some of them have been upheld on some courts. So yeah, as it's going on and the courts are trying to deal with this stuff, some courts are like, nah, we like the mutilation of children. We think mutilation of children is great. We're not sure what the legislature is all about. But the other states are like, nah, that mutilation is pretty stupid. We shouldn't allow that. All the laws banning the genital mutilation surgery for the minors, although rare, with fewer than 3,700 performed on the US on patients starting as early as age 12. See, that's a problem to me. I don't think you should be doing the genital mutilation of the 12-year-olds. This is my bold proposition. I don't think you should be doing it on 13-year-olds, 15-year-olds, 16-year-olds, or 17-year-olds for that matter, by the way, because I don't think that they, have the ability to understand and consent to such lifelong implications. I'm not necessarily sure they necessarily understand it at 18 either, but we have to draw the line somewhere. So 18, they're adults and they want to do something, I guess, knock yourself out. But the 12-year-olds, yeah, I have a bit of a problem with the genital mutilation of the 12-year-olds. It's not clear how many of those patients were 18 when they received the surgery. Well, not all of them were, that's for sure. There's more variation, though, in how states handle puberty blockers, which incidentally are often the exact same chemicals given for chemical castration purposes to sex offenders. So when they say puberty blockers, just read in chemical castration because, yeah, under the bans, Georgia law does not ban those for minors. Some others do, but some states, North Carolina, Utah, allow young people to continue taking them who already have started, but not saying new ones can do it. Others require treatments to be phased out over time. These treatments are accepted by the major medical groups for some reason that defies my understanding. I'm not quite sure why all these major medical groups say we're cool with the chemical castration and the physical castration and the surgeries and the genital mutilation. Not quite sure why all those medical groups say, that's super duper cool with us. But, I don't think that they're right. I think that they're wrong. And yeah, we're not going to allow that. James Thurrow said the treatment at Washington University Center changed everything for their stepson. I bet it did. I bet it did in many interesting ways. Okay, they're now earning A's and B's instead of C's, has a girlfriend and a group of close friends. His depression, anxiety is pretty much dissipated because of receiving this care. Well, that makes it totally worthwhile, right? He's getting slightly better grades in school. That means that everything is A-okay. No problem, right? Everything's just super duper duper wonderful. He has closer friends. He's getting better grades. Everything is awesome. And it will continue being awesome forever, right? Right? He'll never regret this. He'll never think otherwise about it. But we're getting that short-term benefit for whatever value it has. So, hey, no need to look into this any further, I guess. He's doing his best ever at school. His teacher was blown away about how quickly his grades shot up. Well, I guess everything is awesome and always will be forever. For its part, the center said in a statement it was disheartened to have to stop care, a decision following a similar one from the University of Missouri, where treatment stopped for minors the same day that the law took effect in Missouri. Both blamed a section of the law that increases liability for providers. So it's like, aha, the problem is we can be sued. All right, the problem is we can be sued. And we don't want to be sued, and we don't want to be sued into oblivion. So it's like, yeah, you can do these treatments. You can do it. But, if someone wants to sue you for it in the future, they can. They're like, whoa, we're not so sure now. Oh, interesting. Once your liability increases, you're a little bit less confident, are you? Under the new law, patients can sue from injury from treatments until they turn 36, or even longer if the harm continues past then. So we're like, okay, we're going to increase that statute of limitations. Normally for a tort or a breach of contract, you're normally in most law thinking 2 or 3 years. That's standard for a breach of contract or tort. Obviously, your mileage may vary. And obviously this is medical in nature. So that obviously changes things. But it's like, how about an 18-year minimum statute of limitations, plus more if they continue to have harm from it? They can sue all the way up until they're 36. Oh, you're sounding less confident about this, are you? Because your liability is suddenly extended so much further. How interesting. How interesting. As soon as you're held responsible for your actions, you're like, whoa, we better back off on this gender affirming care. Maybe they'll change their mind in the future. Maybe they'll change their mind in the future and think that this wasn't so great. Wait a second, they'll change their mind in the future, you say? They'll change their mind in the future? I thought that's what the conservatives have been saying all this time, and now you're worried about it too. You're suddenly worried about it as soon as your liability matches that. How interesting. The law gives healthcare providers the burden of proving the harm was not the result of the puberty blocking drugs, and the minimum damages is $500,000. So they put a statutory minimum on it. So it's like, yep, it's going to cost you at least $500,000. You have to prove the harm wasn't due to the drugs, and they get a minimum of 18 years to file their claim. And suddenly it's like, oh my God, these people might change their mind in the future. They might have second thoughts about it later in their life. We might get sued about it. Suddenly feeling a lot less confident, aren't you? We're beginning to win. Neither State Senator Mike Moon, who was the primary sponsor of the Missouri ban, State Senator Justin Brown, nor Dale White, whose committee advanced the measure, responded to questions. But, they're like, yeah, the people have the right to sue, and as a result, they're not going to give the treatments anymore because they don't want to be sued. In North Dakota, the law allows for treatment to continue for minors who were receiving care before the law went into effect, but it does not allow the doctor to switch the patient to a different kind of medication, and the North Dakota law allows patients to sue until they turn 48. So North Dakota took an even more aggressive picture. How about instead of 18 years, how about 30 years? How about a 30-year statute of limitations? How about they can file a claim anytime in 30 years? And suddenly all the providers are like, whoa, wait a second. People might change their mind in the future. This 12, 13, 14, 15, 16, 17-year-old who's super duper confident now and we're giving the treatments to now, maybe they'll change their mind in the future. Maybe they'll have second thoughts about it. And if they do, they could sue us because they have second thoughts because they changed their mind in the future. Suddenly feeling a lot less confident about that gender affirming care, aren't you? Suddenly feeling a lot less confident that those decisions are real, heartfelt decisions, and they really reflect an inner truth that will never change their mind. Suddenly feeling a lot less confident when you're like, oh, I have liability for 30 years. Being a little bit more cautious about it, aren't you? Uh-huh. Providers, as a result, have simply stopped providing the chemical castration and physical castration care, according to Brittany Stewart, who is a lawyer for gender justice, who is suing over the ban in the state because she'd like to continue doing the genital mutilation. To protect themselves from the criminal liability, they've just decided to not even risk it because the vague law doesn't give them enough detail to understand exactly what they can and can't do. Yeah, if these people have, second thoughts about it in the future, they can sue you. So they don't have enough confidence going forward. So, yeah. Jasmine Beach Fiera, the executive director of Campaign for Southern Equality, says it's not just the liability clauses that causes the problem. Across the South, where most states have adopted bans on the chemical castration, physical castration, and genital mutilation policies for the minors, she says she's heard of psychologists who wrongly believe the ban applies to them, and pharmacists who stop filling orders for the minors, even in place where the laws are on hold because of court orders, because no one wants to get sued. No one wants to get sued. It's like, these people, I thought your position was these people, these were deep held beliefs. They've been insistent, persistent, and consistent, and they'll never ever change their mind. Let's give them the chemical castration, physical castration, genital mutilation policies. And suddenly it's like, wait a second, maybe they'll change their mind in the future. Maybe we'll get sued. And the pharmacists don't want to fill the prescriptions. And the psychologists don't want to do it because they don't want to get sued. Suddenly everyone's feeling a lot less confident, aren't they? One of the lawyers who would like you to cut off the bits of your kids says, quote, "It's hard to overstate the level of kind of chaos and stress and confusion it's causing on the ground, particularly for people who live in more rural communities or places where even before the law went into effect, it still took quite a bit of effect to get the genital mutilation." Yeah, now it's going to be a little bit harder to find those doctors, I guess. For a 12-year-old named Tate Delaney in Fargo, North Dakota, the continuing care for the 12-year-old means traveling to neighborhood Minnesota for medical appointments. The 12-year-old is undergoing gender-affirming care, and they were doing it in North Dakota, but now have to travel to Minnesota because they can't get the gender-affirming care they need as a 12-year-old. As a 12-year-old. According to mom over here of the 12-year-old, mom says it's not right and it's not fair that our own state government is making us feel like we have to choose between the health and well-being of our child in our home. The 12-year-old. Mom would like to have the chemical castration, physical castration, and presumably genital mutilation of their 12-year-old. And apparently mom doesn't see any problem with that, and she's frustrated at the great state of North Dakota making it more difficult for her to get the care for her 12-year-old. So, yeah, okay, that's a difference of views. In the meantime, the family does what they've done best, saving leftover testosterone from vials. They have enough doses stockpiled to last a year. Well, how exciting. All right, let's wrap this up. Thus, that brings us to the end of the story for the moment about how some states are fighting back against the chemical castration, physical castration, and genital mutilation policies for the 12-year-olds. And some parents of the 12-year-olds would like to continue doing that thing. And some states are saying, maybe this really is a problem. And the children, don't fully understand what's going on. And the parents are like, no. They fully understand what's going on. This is a deep-seated belief. This is deep-seated. They really are a child in the wrong body. And, they really feel this way. And some states, they're like, okay, but if they don't really feel that way for, 30 years, they can file a lawsuit. And some of the providers are like, maybe we should take a second look at that. Maybe we're a little bit less sure. Interesting how they were so confident as providers. Yes, these children really need these things. They really need the chemical castration, physical castration, genital mutilation. They really, really need those things. These children are trapped in the wrong body. They are insistent, persistent, and consistent. And people say, okay, but they can sue you for 30 years if they change their mind. And suddenly the medical providers are like, whoa, wait a second. Maybe we should slow down. Maybe we should slow our roll. Maybe we're less confident. How interesting. How interesting they're suddenly less confident. So some states have banned it, and even in states where they haven't banned it, some of the medical providers beginning to take notice of some of the lawsuits beginning to get filed. So the war is being won. And at least for the moment, that brings us to the end of discussion of this story. All right, and good morning and welcome everyone to Uncivil Law. I am your host, Uncivil Law, as always, and I am happy to be here with you. I hope you're having a great day. I'm having a great day. Life is good. I hope everything is wonderful wherever you happen to be. Culpertistic in chat says, this reminds me of what you were saying about something about being an officer of the court in the Paxton trial. All of a sudden, you're a lot less sure of anything when there's liability on you. Yeah. It's like, I'm sure of this. It's like, are you sure as an officer of the court? It's like, as an officer of the court, I'm not even sure I'm an officer of the court. It's like, I'm not sure about anything. Suddenly when my ass is on the line, I'm a lot less confident. Yeah, right? Yeah, when your ass is on the line, suddenly it's like, maybe I should be a bit more cautious here. Danger. You're about to put your ass on the line. Are you really sure? Are you really sure, counselor? Are you really sure? Bitch, I'm not even sure what my own name is at this point. Yep, exactly true. Yes, Paxton has his job back. He got his job back immediately. So he is back at work. All right. Let's try covering this lawsuit or this story. Let's see where this goes. For the 113 of you who are here, by the way, good morning. Hope you're having a wonderful, beautiful day. I had a nice workout yesterday. That was plus. Got to get my swole on. I was doing wide bar pull downs yesterday. So like the day before, I was doing these V ones. So you're real tight, doing these because of the V grip on the lat pull down. So you're like, your hands are here because of the V, and you're just pulling down like straight like this. And yesterday I was doing these wide grips. So basically the exact opposite. My hands are basically as wide as they can be doing these pull downs. Really stretch out different part of your back. Badass. So that was fun. I wasn't able to do as much weight on the wide. I think yesterday, I'd have to double check the numbers, but I was doing something like 170 pounds on the V, and I think I was doing something like 130 or maybe 140 on the wide. So I lost like 30 to 40 pounds because of the difference of the grip, but you're working different parts of your muscles. So, that's kind of to be expected. And also part of the point, right? Is you're working different muscles and you're working them differently. So it's part of the point of mixing it up in the first place. So, hey, it's all good. I was also doing these cable deadlifts. They have a free motion machine. And so you just put the arms of the free motion machine all the way down so that the pulls are all the way on the floor. And then you do deadlifts with that. A little bit easier than doing them on a barbell where you have to load the weights and stuff. So a little bit easier to do that. Artie says Senator Menendez has been charged with bribery. Who's Senator Menendez? Who is that, and why do I care? All right. How long have I been doing this routine? I don't know. Something like 2 to 3 months since I've been using the new app. It's been good. It's been good. I was also doing, what would you say? I don't even know what the name of the exercise would be, but I guess I'll call it a vertical cable row. So you, again, with the cable machine, you put the arm all the way on the bottom and you use a straight bar and you pull up on the straight bar. So you just pull up straight vertically and it works your triceps. That was pretty fun. All right, let's do another one. In alleged racial discrimination, even in my woke media company news, creators at TikTok say they were fired after they raised complaints to Equal Opportunity about racial discrimination. So they say that, they were invited into the organization, with warm and fuzzy and, big applauses, for diversity. But then once they got there, their treatment actually, not so kind and not so nice. So the reality was not exactly, the outward appearance of the company. And they filed a complaint to Equal Opportunity, and then they got fired, which, if true, of course, would be illegal. You can't fire someone for being a whistleblower, and you can't also fire someone because of race. So it'd be doubly illegal. So that's apparently what's going on. So let's learn a little bit more about woke media company TikTok and their apparent problem with racism. Let's get started with this. A senator from New Jersey? Okay, all right, great, fine. I thought TikTok was Chinese. They are, but they have American employees too. So, yeah, still illegal. All right. Ninette Matma said she was attracted to work at TikTok because of how the social media platform was really built upon Black culture and the work of Black creators. She said she saw and welcomed TikTok's pledge of support for the Black community in the wake of the 2020 police incident involving George Floyd and applied to work at the company because she thought the corporate values resonated with her. So the company, according to her, was making all these outward sort of demonstrations about how much they love, how much they love African Americans and how woke they are and how much, they welcome different creators, especially Black creators. And she's like, okay, I'm going to go work for the TikTok. So she applies and begins working there, but the reality apparently was less accommodating. Shortly after she began working at TikTok's parent company, ByteDance, she says that she encountered toxicity and racism in the workplace. Apparently, the reality was not exactly what they were showing on the label. Her manager, according to her, would refer to her as a black snake behind her back and set unrealistic and uneven expectations for her compared with white peers. So she's like, okay, my boss is demanding more of me and making things unfair compared to my white colleagues. Maybe it's because of race. The mistreatment, according to her, only got worse, she said, after she spoke up about it to Human Resources, because she misunderstands what Human Resources is, as so many people do. Human Resources is there to protect the company, not you. Not that they'll particularly make that clear because they want to protect the company, not you. So yeah, she goes to Human Resources. Amazingly, things got even worse. Matma is one of 2 Black former ByteDance TikTok employees who together filed a formal complaint with the Equal Opportunity Commission, saying they were discriminated against on the basis of race. So 2 of them went to EEO and said, okay, the racism. Their complaint asked the agency to investigate the discrimination and retaliation at TikTok. Corporate America, of course, has come under fire for various instances of racism in the workplace. The criticism especially pointed for the technology companies who make all these outward shows, but then in reality, not so much in the workplace, where having employees with diverse perspectives is critical because of the tech products. Matma, who was based in New York City, and fellow former employee Joel Carter, who was based in Austin, Texas, how you doing, fellow Austinite, allegedly proposed in the class action complaint they each faced repeated instances of discrimination and then faced retaliation when they went to complain about it, which would be illegal, right? You can't do that. You can't retaliate against someone for making a formalized complaint. That's why they're there. So it's like, okay, you discriminated against us, and then we went and made formalized complaints about it, and you discriminated against us more, which would be illegal. So that's what they're saying, at least. According to their complaint, rather than holding anyone accountable, TikTok denied the blatant discrimination that Miss Matma and Mr. Carter suffered, failed to stop it from continuing, engaged in sham internal investigations, took away their work, and then eventually terminated them in retaliation. So we apparently discriminated against them at work, and then when we complained about it, they fired them, which, you can't do that. So now we're into the dispute, right? Is it because of race? Is it not because of race? What is the real reason the company is doing this? So that is where, as always, things get interesting. The complaint says that they're asking the Equal Opportunity Commission to investigate TikTok to see if there's a pattern or practice of retaliation against workers who complain against discrimination. TikTok itself, for its part, at least has made outward acknowledgments about the important role that Black people would play for its platform. So saying all the right things in public, in their public-facing ways, you would kind of expect them to do. Of course we like the Black people. We love Black people, but how is the treatment actually inside the company? TikTok saying, quote, Black creators inspire mainstream culture and continue to find what's next. From creating viral moments and pioneering new spaces in fashion and music to advocating for others and organizing for a better future, they've always been at the forefront of innovation, the company said in a statement. So, saying all the right things overtly, saying all the right things externally, trying to put on that sheen, but how are things in the reality? Maybe things in the reality not necessarily what they're saying publicly. 2 years earlier, TikTok had acknowledged concerns that Black users felt unsafe, unsupported, and suppressed, and vowed to actively promote diversity on the platform, but how much that actually happened, who can say? Carter, for their part, who began working at TikTok in June of 2021, told CNN in an interview that experience at the company was both dehumanizing and demoralizing. Carter was initially hired as a risk analyst, responsible for managing safety of TikTok's ad ecosystem, but was transferred to the platform's ad policy team as a policy manager 8 months later. Shortly after starting this new role, Carter alleges, he discovered that he was being significantly underpaid compared to his colleagues. Carter was at the time the only Black employee on his 80-person ad policy team. So doesn't seem like it might be the most accommodating place known to man. Carter's manager prevented him from attending important meetings according to the complaint and took credit for Carter's work. Carter alleges in the response to complaints, his role as the company was changed and severely diminished, prompting him to again alert human resources that he was concerned about discrimination and retaliation. So he made formalized complaints about it, apparently retaliated against, he makes more formalized complaints against, more retaliation, and so forth and so on. The complaint that he filed with EEOC shares part of Carter's performance evaluation, where he was given an overall score of exceeds expectations. So at least in April 2022, the company was saying that he was a good employee who did good work. In his performance evaluation. So they said, he's a good employee. And so that makes it a little bit more difficult to claim that they fired him because, he's a bad employee, because his evaluations say he's a good employee. So, there's that. A reviewer described Carter as open and humble above all and a great teammate. Sounds like he's a good worker. Sounds like he's getting along well with everyone. Yet we can't help noticing that when he went and made complaints about racism, that suddenly he's treated worse. So why was he treated worse? Was it because he's a bad employee? I don't know. His evaluations don't seem to reflect that. The evaluation also continued to say he was happy to provide assistance or guidance whenever needed. He never had an ego, was always open to collaboration and feedback. But after Carter began raising concerns at work about racial discrimination, he alleges he was retaliated against in a performance review in April 2023, suddenly being labeled as tense and angry and accused of slamming doors in the office. But Carter said he never slammed a door. In fact, the doors are hydraulic, not capable of being slammed. So, there's that. Carter told CNN he felt his managers were trying to establish a narrative about him being an angry black guy. Carter grew emotional as he talked to CNN about the pain, saying the historic significance of using that kind of inflammatory language, especially when it's unfounded. His experience at work deeply impacted his mental health, and for the first time in his life, he began seeing a psychiatrist and dealing with symptoms of depression. I feel you, my friend. I feel you. As a person who suffered with depression, I understand. And you're situationally depressed because, you're having these problems at work. It's like, I understand. I feel you. I feel you. It was overwhelming feelings of hopelessness and helplessness. I understand. Matt Ma, who worked for sales for Lark, who is ByteDance/TikTok's workplace communication division, similarly alleges they were treated differently from colleagues on her team who were nearly all white, according to the complaint. For example, Matma said she was not given adequate time to complete required onboarding courses before being asked to start her work, so she had to finish courses during nights and weekends. By contrast, Matma's white colleagues were given ample time during normal work hours to complete their training before they were required to start their sales overreach. In a January 2023 complaint, Matma was told by her colleagues and manager that they commonly referred to her as a black snake, which is not particularly encouraging, when you have that kind of language. So, that's not exactly good. The outrageous black snake nickname was not the only racially derogatory and inflammatory, but also suggests that Miss Matma was deceitful, untrustworthy, and sneaky. Matma and Carter both alleged that they had multiple requests to switch managers, which were denied, and complaints to HR similarly were denied, both ultimately being terminated by TikTok in August. So even though a year earlier, they were great employees who got along well, exceeds expectation, great team player, and so forth and so on, a year later, they're being fired because they're completely unworkable, they're completely bad people, and all the rest of it. So, okay, that seems a bit suspicious. So, yeah, it might represent a problem. Now, Matma, for her part, says she feels a moral obligation to share their experiences publicly. When there's an injustice happening, it festers in the dark and the shadows. By going public, we can inspire others who are still suffering to stand out here and speak out. Thus, that brings us to the end of this lawsuit, which has been filed by two black creators against TikTok. Both employees apparently were rated as very, very good employees, but then they began to have problems internally, and they say it was because of race. They made complaints, the problems got worse. They made EEOC complaints, and they got fired. So it looks like it might be racial discrimination. And yet another woke company who makes these outward statements that, you know, they're here for their employees and they're here for the diversity and all the rest of it, but how they really treat people in the real world, not that. So yeah, not particularly surprised. We got a little hypocrisy there from the woke companies, at least for the moment. That brings us end of discussion of this story. Push the button. Great. Thank you very much, Tammy, for your kind super chats, or your gift memberships. They are extensively appreciated as always. Culper Citic says whether or not they're great employees, documentation says they were, but a lot of people get lip service says how great they are in documentation. Well, the documentation, as you might expect, goes a long way in any sort of lawsuit or filing. That was part of my video yesterday about how to protect yourself as well. It's like documentation is your friend, man. Documentation is good for the employer, it's good for the employee, it's good for everybody, right? 2020 SGD from Nick. Thank you very much for the kind super chat. There's currently a bunch of Aussie politicians over there talking to your politicians. I get the obvious bifurcation of traitor and hero, but anyone else notice a huge disparity of people giving a shit between Assange and Brand? I don't know if I see a disparity or not. Assange's stuff is a little bit in the past at this point, so there's not certainly a current focus on Assange, but at least at the time when like Assange was in the news and these stories were about Assange were in the news, which, you know, is a little bit in the past, but I'm not sure that I agree that there was, I'm not sure that there was wild disparity between the two. If anything, I think at the time, excuse me, if anything, I think at the time, maybe Assange was getting more than Brand is getting now. But that's a little bit subjective. But I'm not sure that I agree that there's a wild disparity between how Assange was treated and how Brand is being treated. Not in the way that you're suggesting, or the way I'm inferring that you're suggesting, at least. So, yeah. Cast the Sass's documentation is kind of everything in an employment lawsuit. Documentation goes a long way. Documentation goes a long way. Yeah. That's why I created that video yesterday. It's like how to protect yourself at work. The memo to file, which is now the email to file. But the email to file is your friend. Because like when your employer tells you to do a stupid thing, or you have a problem that your employer is going to eventually deny, or whatever it is, the email to file saves your ass. It's great. Too High Strong gifts 5 gift memberships. Thank you very much for your kind contribution to this channel. It is extensively appreciated. We appreciate everyone who supports the channel. It is great. Let's see, where am I? Let's see. All right, let's cover this story. Da 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 da. I certainly am here with you, Sandy, and I'm happy to be here with you. I'm having a good day today. I had a good workout yesterday. Here's something that I continue to learn literally every time I go to the gym and then forget. Apparently I have a learning deficit when it comes to the gym, because when I go to the gym and I work out, I feel better. And then if I could just remember, hey, when you go to the gym, you feel better and you don't feel good. Maybe if you went to the gym, you'd feel better. You know, maybe if my mind could, you know, draw the correlation the other way, it's like, I went to the gym, I feel better. Wait, I don't feel so good. Maybe if I went to the gym, I'd feel better. Maybe if I could make that logical leap, right? That'd be really good. But for some reason, I forget every single time. Going to the gym makes me feel better. If I could only remember that and then, you know, draw the correlation. Hey, I don't feel good. Maybe I should go to the gym. Uncivil Law has a learning problem. All right, pressing on. I was so woke, it caused me problems, and now I have to go to the Supreme Court to fix my own shit news. California cities are begging the Supreme Court of the United States to fix their shit. So the California cities were like, hey, we love the homeless. Homeless are great. Who would ever discriminate against the homeless? The homeless are wonderful. And then the homeless built camps on the sidewalk and they stayed there for years and years and years and decades, and it led to all kinds of problems. Drug use, poop on the streets, all kinds of things. And finally, they've had enough. And they're like, U.S. Supreme Court, could you help us by please giving us the legal right to not do this? Because our own woke Ninth Circuit said we can't throw them off the sidewalk. Could you please fix our shit? So watching the left beg the conservative Supreme Court for permission to get rid of the homeless encampments is pretty hilarious. Let's learn more about this. Finally fed up with its own homeless encampment problem, California local officials are seeking help from the conservative Supreme Court. That mean bastard conservative Supreme Court. Please help us. We're overwhelmed. We want our streets back. In a legal brief filed Tuesday with the United States Supreme Court, the California State Association of Counties and League of California Cities told justices that the string of federal court rulings, principally from the Ninth Circuit Court of Appeals over the last 5 years, that said, hey, cities, you can't get rid of the homeless encampments, you can't clean your streets, have made the problem unworkable. So, the Ninth Circuit said, you can't get the homeless off the street because they have nowhere to go. You can't force them off the street. You need to build homeless shelters. And then, of course, they can't build homeless shelters because no one will let them because of NIMBYism, not in my backyard, right? So people were like, why don't we give the homeless shelters? And then they don't want to let them build it. And then when they do, they have to be palaces and they're way too expensive. So it's all a bunch of shit show. Quite literally, as the poo flows the streets of San Francisco, I've been there. I can testify to it personally. So they're like, this needs to stop. Writing in their brief, the state of California and its cities and counties are engaged in unprecedented efforts to address homelessness through the creation of significant new policy initiatives and funding. However, this is where the rubber meets the road, right? Nothing before the word but counts. Camping ordinances can be a useful tool in appropriate circumstances in addressing problems. In other words, we'd like to prevent people from camping on our streets and just staying there. We would like to say that people do not have the right to just put up a tent literally on the sidewalk and just stay there for years and years and years at a time. Camping ordinances can be a useful tool, say very, very carefully to their conservative Supreme Court friends. The California cities have made a similar appeal in 2019, but that appeal had been denied. This all ultimately stems from a 2018 decision by the Ninth Circuit Court of Appeals coming out of Idaho that, of course, is also binding on California because it's the Ninth Circuit Court of Appeals, and the Ninth Circuit Court of Appeals covers California just like it does Idaho. So when it comes to federal law, what's true for Idaho would necessarily be true for California or Hawaii or Alaska or Washington State. The Ninth Circuit covers quite a lot of territory. The judges of the Ninth Circuit ruled in 2018 that it was unconstitutional to criminally penalize people camping in public when they lack adequate access to a shelter. So it's like, okay, you know, you can't force them off the streets if you don't give them anywhere to go. You know, you're not giving them any alternative. You're not building the homeless shelters. And then, of course, they can't build the homeless shelters because no one wants them. And also, they demand that the homeless shelters be super duper nice, right? Every person needs their own personal apartment, and the apartments need to be nice. $100,000 of construction cost apiece. Amazingly enough, they can't get anything done. So it's, yeah, the ultimate thing where everyone goes to the city council and they're like, you know, I totally support the homeless. I totally support the, you know, the needs of this community, but not like this, not here, not in my town. The NIMBYism is real. So the Idaho Ninth Circuit, which is also the California Ninth Circuit, said you can't force them off the streets if you don't give them anywhere to go, and they can't create new places to go, so they're just constantly camped on the street. Since then, cities have often landed in court when trying to enforce their camping bans, but organizations say those cases haven't clarified what's allowed or not. And of course, since COVID, the homeless crisis has only worsened, with more than 170,000 homeless people this year. Most of them are unsheltered, living outdoors because the cities don't have enough beds. In some cases, the people, of course, refuse to go to shelters because of various reasons. The shelters aren't always nice places. Sometimes there's violence. Sometimes there's theft. Sometimes whatever. So sometimes people don't want to go to the shelter, and according to the law, you can't make them. You can't force them off the street. And it's like, wait a second, this person has taken private ownership of the public street. See, the thing is, the street and the sidewalk and the parks are public, which is to say they belong to the public generally. But this particular person has set up a tent here and is staying there and literally transforming public property into private property for their own personal use, right? They're just staying there forever, personally. And so it's like, well, that property doesn't belong to you. It belongs to the public in general, in a generalized way for everyone to use. You know, to use the sidewalks for the walking and the streets for the driving and so forth and so on. But these people are like, nah, I'm just going to camp out here forever. And California right now can't make them. And they're begging the Supreme Court to fix their own shit. It's hilarious. The crux of the current legal debate is what makes a person involuntarily homeless and whether cities can sweep camps and cite residents even if it doesn't have shelter, which under first basic law principles, the answer is yes, you can. The fact they have nowhere else to go is not a problem for the government. The Constitution of the United States and the laws of the states, generally speaking, to the extent they prevent the government from doing things. They don't require the government to do things. Typically speaking, like the Constitution is all a bunch of negative rights. You know, Congress shall make no law. That's a negative right. It's about what Congress can't do, right? No unreasonable searches and seizures. That's a negative right. It's about what the police can't do. The Constitution doesn't require the government to do things. So the fact they have nowhere else to go is not the government's problem. Get off our streets. Get off our streets. But California can't make them right now, but they'd really like to. The California Association's filing the amicus brief supported an Oregon city also within the Ninth Circuit, because Oregon, of course, also within that circuit, this year that ruled that Oregon can't enforce a camping ban because the city doesn't have enough shelter beds. So Oregon has very similar problems to California in this domain. On Wednesday, more California officials also weighed in. The state sheriff association and police chief, as well as a group of Orange County cities, filed their own brief arguing the Idaho ruling may have expanded the rights of those suffering from homelessness, while the rights of business owners, taxpayers, children, and other house citizens to clean, safe streets have been completely ignored. Right. The streets are there to serve the public in a public way, not any individual person. You don't have a right to go there. You don't have to go home, but you can't stay here kind of thing. Find somewhere else. And they literally can't right now. And it's led to this wonderful, Skid Row and all this crap in all these places, and they're begging for help. The Sacramento County District Attorney filed their own brief, and San Diego has also filed a brief circulated by Seattle, according to the mayor of Seattle. A lot of woke cities suddenly tired of, having to deal with this. Will Knight for the National Homelessness Law Center says they don't think the Supreme Court will take up the case, given that it's not come up in other federal circuits. Which, fair enough. That is a reasonable prediction. The U.S. Supreme Court, they're a court of limited cases. And one of the ways you look for a decision from the U.S. Supreme Court is from circuit splits. And right now there is no particular circuit split because, other circuits aren't this dumb. And so they're like, we don't think the Supreme Court will take up the issue. I don't know. I think they might actually. Knight criticized cities for trying to get around the technical boundaries of the Idaho ruling instead of expanding individualized housing options, which they can't do for all the reasons we've discussed. Meanwhile, political pressures mounting on cities to strictly enforce their camping ban because people are tired of it. Democratic big city mayors and Governor Gavin Newsom have blasted federal judges for rulings that halt the encampment sweeps. So they're like, yeah, we can't get rid of the homeless encampments. Those damn federal judges forcing the homelessness on us. Yeah. On Tuesday, there was a suit filed against Sacramento accusing of inadequately enforcing a number of camping bans, such as those near schools, and ignoring residents' requests for safety issues at the camps. City officials have not used criminal citations, instead opting for voluntary compliance, which does include ordering people to move their tents, but of course it's voluntary, so a lot of people are just like, no, I'm not going to move my tent. You literally can't make me. You literally can't make me move my tent because you don't have any power right now because your own policies have come to bit you in the ass. Perhaps because of these policies that are, preventing them from doing things, homelessness has increased 60% in Sacramento County to 9,300 individuals. The city and county have about 2,400 shelter beds. So they're only short by 7,000. And they can't build any more. So partly perhaps because of this thing, people are going here to be homeless because of the policies that they themselves can't change. So they're begging the Supreme Court for help. Okay, let's wrap this up. Thus, that brings us to the end of the case for the moment about a bunch of California cities begging the U.S. Supreme Court for permission to get their own streets back. They're like, we love the homelessness, but, it'd be nice if we had the ability to maybe, enforce camping bans sometimes. That would be nice. Can we please enforce our own camping bans? The Ninth Circuit said we can't. And we totally love the homeless and we'd love to build the shelters, but, maybe camping bans would be nice too. Can we get our street backs, please? Please, can we have our street backs? And the mayor of Portland and the cities and counties of Colorado and Idaho and everyone are begging the Supreme Court for help. So maybe that super mean conservative Supreme Court will bring them relief. And then when they do, they'll all complain about it, which will just be the ultimate in this, right? You know how the story ends, right? The Supreme Court gives them exactly what they want, and then they complain about that arch conservative Supreme Court, how mean of them, how very disrespectful to the homeless, as they then get the street sweepers ready to go. So you know how the story ends if the Supreme Court grants it, but they may grant it anyway. We'll see. At least for the moment, that brings us to the end of discussion of this case. Push the button. Whoa. This is what happens when you forget to take off the filter. Although that looks pretty metal, I have to say, in the background. There we go. All right. Okay. I was doing a video for Attorneys React yesterday, and I use a green screen when I film those videos, and I forgot to turn off the green screen filter. So then when the green light showed up on the plaque, my green screen filter tried to remove the green screen and put in a different background because, you know, that's what it's for. All right. This story is a little enraging. Fair warning. But, you know, it's reality. So let's do reality now. All right, let's do this. In Not Everyone Necessarily Deserves to Be Set Free from Jail on Bond news, a woman went to jail for mistreating a teen and then was sent out on bond and then did it again within a week. So maybe not the best person to let free on the streets. Can't help noticing that she was physically abusive in a unacceptable way with the young teen, but it's okay. Let's let her out on bond. She learned her lesson, and a week later, oh no, it turns out she didn't. So let's learn a little bit more about this story. Let's get started with this. David, that's not cool. A woman out of Carroll County, Georgia, allegedly physically abused a child in a touchy-feely kind of way who was 14 at the time, got arrested for touching the 14-year-old boy, and then did it again within a week. Mackenzie Cook, who is 24, is back at a local jail, this time without bond. Well, apparently we learned our lesson at least the second time around. That would be great. It all started with a missing persons case, according to the synopsis from the sheriff's office. The boy's aunt reported him missing and suggested Cook was the perpetrator. I don't know that I need to say this, but apparently I'm going to anyway. It is not okay to joke about maybe the boy liked it. That is not cool. We're going to apply a consistent standard over here when it comes to such things. We wouldn't say that about a girl. We're not going to say it about a boy. It is not acceptable. And joking about it is not cool. So this is your only warning on this issue. Okay? It is not cool. Right? Let's have a consistent standard. Okay? If it's not okay to do it to a girl, it's not okay to do it to a boy. Logical consistency. All right. And saying it's okay is not acceptable. So don't do that. The aunt further advised of having learned of there being an inappropriate relationship between her nephew, the 14-year-old, and Mackenzie, as he's shown other juveniles images of himself and Mackenzie on the cell phone. So yeah, there was some photographic proof of them together in an inappropriate, prurient manner. The device was turned over to investigators. Deputies claimed they tried multiple times to get someone to answer the door at the home, but no one answered. A sergeant of the sheriff's department managed to get her number through one of the relatives, and the boy returned home 10 minutes later. When investigators finally got in touch with Cook, she initially denied having been there, but then said he was there on the night of September the 5th, according to authorities. Upon completion of a forensic examination of the phone and tablet, inappropriate images were located. Inappropriate images of a child. There's a name for that. That's not good. So she's also in jeopardy of being charged with the manufacture, let alone possession, of prurient images of a child. So the feds might want to have a word with her too. Cook was arrested September 9th for the child touching and enticing a child for the indecent purposes. But then she was bonded out of jail and it happened again. It happened again. So apparently did not learn her lesson well the first time. On September the 14th, the 14-year-old's aunt reported him missing again. She knew the boy had run away about a week before of him being at Cook's home and Cook being arrested on the charges. Deputies said they went to Cook's home and tried to get in touch with her. As deputies were knocking on the door, another deputy looked into the window and observed Mackenzie, the adult, to be sitting on a floor wrapped in a blanket as if she was trying to conceal herself. Deputies continued to give Mackenzie verbal commands to open the door, which she finally did. Upon deputies making contact with Mackenzie, she was nude and wrapped in a blanket, which, you know, is a little bit weird. She claimed to not know where the boy was, but then he walked out from a back room while wearing only boxers. Well, you know, that's sort of a clue. You know, she's naked, he's in a back room wearing boxers. Doesn't take a lot of mental energy to put two and two together. Cook was therefore arrested again for the child touching and enticing a child, and also for obstruction, and this time held without bond. Thus, that brings us to the end of the story of Mackenzie Cook, pictured here on the left from her mugshot September the 9th, and on the right from her mugshot on September the 14th. Because she did it again within a 5-day span. So she touched the 14-year-old, manufactured pictures of a child in a prurient state, and, you know, had possession of the photos of said child that she manufactured, and then was let out on bond, and then did it again. So it's not going really great over here for Mackenzie Cook, and the feds might also want to have a word with her for the manufacture and possession of the child pizza. So, you know, that's a problem. And that, for the moment, brings us to the end of discussion of this disturbing story. Push the button. Yeah. All right. I think I'll skip that story. All right, you need a palate cleanser. I'm not sure I have a lot of palate cleansers. I don't know if this qualifies as a palate cleanser, but we'll give this a shot. And just because the GPS tells you to do a thing, maybe you should make sure that doing the thing is wise news. A negligence lawsuit has been filed over Google Maps after a man died driving off a collapsed bridge. Well, it wasn't really good that Google Maps was giving him bad directions, but, just a friendly reminder, if the GPS tells you, to drive off the collapsed bridge or drive into a lake or something, which occasionally has been known to happen, you use your common sense. The GPS is not God and doesn't know everything. So, might want to look out there, but Google Maps might also be responsible. So let's learn a little bit more about this. A woman has filed a negligence lawsuit against Google on behalf of her husband, claiming her husband died after driving his car off a collapsed bridge because of Google Maps. Philip Paxton, father of two, drowned near Hickory, North Carolina, the night of September the 30th, 2022, according to a lawsuit filed in Wake County. The suit alleges that Paxton was following directions using Google Maps while driving through an unfamiliar neighborhood on the way home from his daughter's 9th birthday party. The suit claims that Google Maps directed Paxton to cross Snow Creek Bridge, which has collapsed in 2013. So he's out visiting his daughter for her birthday. That's nice. That's a good thing to do as a father. Spend time with your daughter. And now you're on your way home. And it says cross this bridge. And the bridge, doesn't exist and hasn't existed for apparently 9 years at this point. So that's a bit of a problem potentially. Paxton and his wife, Alyssa, had originally planned for their daughter camping trip, but came up with alternative plans because of a storm. Instead, they threw a camping-themed party at a friend's home. So originally, they were going to celebrate the birthday by going camping, which, fine, I guess. I mean, maybe that's what the kid wants. Camping is cool. If you like the camping, then, cool. But the weather wasn't really great, so they're like, okay, we won't do the camping, but we'll, pretend. We'll pretend to do a camping, which, hey, that's also cool. So they threw a camping-themed party at a friend's home, which is about 50 miles north of Charlotte. Paxton had never been to the home before that day and was generally unfamiliar with the Hickory Woods development, according to the suit. He and his wife drove to their home separately. His wife went early to help set up, and Paxton stayed late to help clean up. So, they're both going to the party. They're traveling to the party. They want to do a camping thing. The camping isn't really working out because of the weather. So they're going to have a camping themed related party instead. And they're driving separately because, they're different schedules. So fine. Following the party, Paxton was following Google Maps directions to make the approximately 10-minute drive home and didn't know about the collapsed bridge. The bridge had no artificial lighting and the area was pitch black at 11 p.m. So maybe, maybe he didn't necessarily have the information that he needed. While following the dangerous directions provided by Google Maps, Mr. Paxton's vehicle drove off the unguarded edge of the bridge and crashed approximately 20 feet below. So he's just traveling along, traveling at speed. The bridge has no lighting. It's pitch black. He's traveling and suddenly there's no bridge anymore. The Jeep Gladiator was found partially submerged in a creek. Woof. I mean, that's rough, man, right? You're driving, the bridge disappears, you fall into the water and you drown. Dude, that sounds like a horrific way to go, man. That sounds pretty bad, man. Can you imagine the fear and horror in your eyes and all the rest of it, man? The struggle. Dude, that sounds pretty bad. Our girls ask why their daddy died, and I'm at a loss of words that they can understand because as an adult, I still can't understand how those responsible for GPS directions and the bridge could have acted with so little regard to human life. So apparently there were no barriers. Apparently there were no, things preventing him from entering the bridge. There was no lighting. A whole bunch of people may potentially be responsible. Google Maps is part of the problem here. The people with the bridge might be responsible, right? Put up some barriers, put up signs, bridge out. That would have been helpful, but no, apparently not. Google also apparently ignored community voices telling them to change the map. So apparently people had reported the outage using the app at some point to Google, but Google hadn't made the change. So that would go a long way to potentially Google's negligence, right? That they were aware of the problem because they've been informed of the problem, but hadn't made the change. So that would be the issue. According to the lawsuit, Google Maps had been notified about the bridge collapse in the years leading up to the death. So the suit includes messages from Hickory Reach resident Kim Ellis, who suggested edits to Google Maps twice regarding the bridge. So Google Maps was being notified of the problem using, a correction tool and didn't make the correction. So that might go a long way towards their negligence, right? Because they were actively on notice. According to Google, we have the deepest sympathies for the Paxson family. Our goal is to provide accurate routing information, and we're reviewing the lawsuit. The lawsuit, of course, also names Terade LLC, James Tarleton, and Hickley Gavin LLC, who they claim are responsible for the road and bridge. Maybe a bridge out sign and some barriers would have been nice. Maybe some lighting that says, bridge out, some stop signs, something like that, some barriers, but apparently not. The road is a private road. In North Carolina, according to the news, the state maintains state-owned roads, but counties do not maintain private roads. So this is apparently a private road, which makes it a private problem. For 9 years, the community of Hickory was needlessly and senselessly placed at risk when the road bridge collapsed in 2013, and one of the largest companies in the world refused to correct its mapping algorithms, despite the fact that people sent them notices about the bridge collapse. For years before this tragedy, Hickory residents asked for the road to be fixed or properly barricaded, and the demands were unmet. So again, this problem had apparently persisted for years, right? The bridge had been out for a long time. No barriers, no barricades, no bridge out, no lighting, no nothing, right? So yeah, it was a matter of time, and the time came. It was a time came. So a bunch of people have a problem. The Paxson family is seeking unspecified amount of compensatory and punitive damages and asking for a jury trial in the suit, I am quite sure. Thus, that brings us to the end of this lawsuit for the moment about the Google Maps. Apparently, Google Maps had been informed. This bridge had been out. And also, apparently, the bridge people knew the bridge was out and had known it for years, but didn't put up some barriers, some signs, bridge out, some stop signs, warning lights, or anything, right? There's just a bridge that was just there that people could just cross, except there was no bridge, and they're driving over it at speed, and there's no lighting, and it's pitch dark, and so, the guy's driving along the bridge, and then suddenly no bridge, and falls into the water and drowns to death in what must be a horrific episode. He must have been absolutely terrified out of his mind. And now he's left a family that is with children that no longer have a father because of this. And so the mother, on behalf of her husband, has sued Google, the bridge people, and everyone else in sight, as one does. Sue everyone in sight, which is kind of what you do when you do these things. Sue everybody. And, you go from there. So we will see how that all progresses. And at least for the moment, that brings us to the end of discussion of this story. Push the button. Yay. The bridge should have never collapsed in the first place. Ideally not, no. But, it happens occasionally. And, ideally, no, the bridge should not have collapsed, but it did. So, moving on to the next thing. You always ask for a jury trial to start, unless you know for sure you don't want one. But you always ask for a jury trial in your initial demand, because you can always waive it later. But if you don't make the request up front, you might lose it. So I don't know whether or not they really want a jury trial or not, but the demand makes sense. All right, let's do another one involving exploitation of children. More exploitation of children news. Fantastic. The world is not always a nice place, people. In Principals of a School Exploiting Their Power news, principals apparently made and shared a meme of a female student's nude breast using surveillance cameras at the school that they had access to. So, it was the principals of the school that apparently observed this child's naked breast on the school security footage and decided to make a meme about it and post it publicly. So that apparently happened. Let's learn a little bit more about this school-related jape. Ania Harmon said it was bad enough when she learned that an image of her exposed breast had made its way into a meme and shared in May with employees of the Sussex Central High School in Delaware. But what made it worse, according to her and her mother, is that based on their information, they believe that this all started with two principals in the school who created the naked breast meme and shared it with other members of the staff because someone thought that was a good idea for some reason. Harmon and White say that Brady Layfield and Matthew Jones, the principal and assistant principal, used security camera footage from the school to make the meme. So, the school has the security footage, for a whole bunch of reasons. And the principals noticed this naked breast and they're like, let's make a meme out of it. So they did. Apparently, they replaced Harmon's face with that of Janet Jackson, but keeping the exposed boob in response to, of course, the famous 2004 Super Bowl halftime show. So, they took the picture of the child with the naked breast from the security footage, put Janet Jackson's face on it, and apparently started sharing it around the school. Again, a bunch of adults in a school apparently thought this was a good idea. Harmon says that they're upset and disappointed about the whole thing. She has therefore sued the principals, alleging invasion of privacy by intrusion and publication of private matters. The lawsuit also names Sussex Central High School and Indian River School District. What do you want to bet they claim qualified immunity? They claim qualified immunity. We had no way of knowing. We had no way of knowing that taking the surveillance footage of the naked school breast and sharing it around as a meme was a bad idea. Should we not have done that? Was that wrong? If anyone had told us that that would have been a problem. A representative of the school district declined to comment, which says it doesn't comment on pending investigation. The David Morrill, a spokesperson for the district, declined to speak about the employment status, saying it's a personnel issue. Layfield's attorney, Thomas S. Nurberger, denied any wrongdoing by his client, who's head principal. He says Layfield was placed on leave, but didn't otherwise return a request for comment. According to Harmon and the lawsuit, it was about 7:30 in the morning on May the 17th. She was walking to class when she encountered two students, a boy and a girl, arguing. Harmon said she told the girl who was screaming to be quiet, at which point the girl screamed obscenities at her and bucked at her, threatening. A woman who works at the school district stepped in and pulled Harmon forcefully, which caused her clothes to come apart, exposing her breasts. So apparently there's a bit of a disruption earlier in the morning at the school, right? The students are looking at, potentially getting in a fight. And one of the school district members, saying, let's break it up, basically, pulls the girl and yanks her away to try to stop the fight from happening. And in doing so, causes her clothes to come apart. So it wasn't because she was voluntarily exposing herself, not that it would really matter very much legally, but, just for the sake of it, it was because, a school district member who probably wasn't doing anything wrong at the time, by the way. This isn't like the school district member was doing something wrong. She's trying to break up a fight. she decides to break up the fight by, forcibly trying to pull the student out of the fight and causing the clothes to tear. Not ideal, necessarily. Maybe there was a better way to go about it, but not necessarily illegal, right? So no one's doing it illegal at this point. The breast becomes exposed because of this and, shows up on the security cameras. So, punish the students for the fight, whatever, get her a new set of clothes, no muss, no fuss. But that's not where it ended. The suit alleges that Jones worked with Layfield and possibly others to create the meme, and that Jones showed it to other vice principals, administrators, and others on a school-issued laptop. The fact that it's surveillance footage from the school does somewhat narrow down the list of possible suspects because, only school officials would have access to the footage. So apparently they heard about the fight. They decided to pull it up on the security footage, possibly to, review it for possible disciplinary charges or otherwise to see, what should be done about it or whatever. And they noticed, shit, kid naked breast. Let's make a meme about it. Apparently 6 people had access to images of the student's breast. White said that a few days after the incident, she started hearing from people in the community the meme existed. I didn't have any proof of that it was my daughter, but all the facts started to add up. Initially it's like, who else could it possibly be? It's like, yeah, it was your daughter. She said she didn't receive confirmation until 8 days later when the assistant superintendent called her to schedule a meeting. By that point, White and her attorney said both men had been placed on administrative leave. The assistant superintendent made no mention of the video or the meme until she was asked whether it existed. White never messed with the assistant superintendent, instead hired an attorney. The school district, of course, has declined to comment. I was in shock. I couldn't process it right away, White said. And then after the shock came down, it was more anger, hurt, and disbelief. So many emotions. Yeah. And to this day, I still have the emotions. So yeah, initially the superintendent wasn't, keen to mention this fact about this meme until they were asked. And then, it's like, yeah, this kind of happened. Without naming any of the people directly involved, a spokesman for the Delaware State Police says that agency is investigating any potential crime that occurred in collaboration with the Delaware Department of Justice, but otherwise did not decline to comment. So, we're also trying to figure out whether or not this is a criminal thing. So we're now just beginning the investigation. Thank you for bringing it to our attention, as they get embarrassed all over the press. The attorney for Harmon says that what happened to her, of course, is reprehensible, and the purpose of the lawsuit is to hold the administrators accountable. No person of authority should ever do that to a student, and we want to make sure it never happens again. Once the investigation is concluded, we hope it will result in criminal charges. Probably not if I'm a betting man, and I'm sure that qualified immunity as part of the civil suit can't be very far behind. We had no idea. We had no idea it was wrong to make a little funny meme with a child express. If someone had told us that was wrong, we would have never done it. The qualified immunity is real. Someone, one of these days, really needs to do something about qualified immunity doctrine, please, for the love of God. Nuremberger, for their part, says Layfield was not involved in creating or circulating the meme, and that Layfield showing the security video to 9 people, including state troopers and some staffers, such as administrators, was with the intent to keep the child safe. I love it. Yeah, Layfield, I didn't create the meme. I showed the footage to 9 different people, but it was all out of safety. That was the reason I did it, for safety. I was doing it because it was procedure. Sure you were. Okay. If the video is ever released, one does not even notice the disrobing from the long distance, which is all the more strange that, the meme was created. So, it wasn't exactly super duper crystal clear on the camera, but, it was there. And, if you do enough zoom in and enhance, apparently you create the meme. Nuremberger placed the blame on the meme on Jones, who he says created it. Nuremberger says the Delaware State Board of Education has informed Layfield it's investigating him and possibly might have revoked his teaching license. Nuremberger says their client is innocent and being used for monetary purposes. It's the money. It's the money, sure. The lawsuit, of course, specifies unspecified punitive damages. Let's wrap this up. Thus, that brings us to the end of the story of Ania Harmon, pictured here, graduating from college, who has learned a little bit about some interesting issues that happened when she was in high school. It was 7:30 in the morning. She was walking the halls and there was a bit of a fight, between the students. One of the staff members tried to break it up, and in doing so, apparently unintentionally ripped her clothing, exposing her breast. And then, of course, where things get interesting from a legal perspective is there was a meme circulating around with, Janet Jackson's face superimposed on her body, but it was her naked breast from the security footage. And, not a lot of people had access to it. So that was happening. So she's suing, for the invasion of privacy and all the rest of it. I imagine qualified immunity will come to the rescue for these principals, because it always seems to. At least for the moment, that brings us to the end of discussion of this story. Push the button. Yeah. I'm not sure this qualifies as CP. It probably doesn't qualify as CP, but it's not good. It's an invasion of privacy, though. It's making things that otherwise should be private public, and so it's tortious. I don't think it's CP though. The other woman with the kid with the molesting, that was CP. This I don't think is CP legally, but I suppose someone could have a fight over whether it's CP or not. All right. Florida woman. So this is your palate cleanser, I guess. As we end the stream, we got your 2-minute Florida woman to try to make your life a little less, horrible. I want to thank you all once again for your continuing contribution to this channel. Is Eric Hunley streaming today? I'm pretty sure he is. I might go on with him today, or at least ask if he wants me on. Let's see, layback news. Yeah, no, I'll send you to layback news, and I may or may not appear on there, but I'll redirect you that way, because that sounds like a nice thing to do. So I'll send you that way. All right, let's do Florida woman. We'll make it funny. Make it funny. All right. For today's Florida man story, we bring our attention to Florida woman who is under arrest after reportedly abandoning her child in a running car while she decided to swim in water in order to meet the alligators. She had a burning desire in her heart to meet her reptilian friends, and she apparently decided she needed it right then and right now, and apparently got out of her running car, abandoning her child so that she could swim with the alligators. Okay, apparently that happened. Let's learn more. The department responded to the call around 10:30 in the morning at Captain Khan's Fish House in Lee County. According to witnesses, the 41-year-old woman, Allison Sarah Daughtry, parked her car near a local pier, turned up the radio volume, jumped into the water, and swam for 20 minutes, all of which during time her child was left alone in the car. Fortunately, the air conditioning was left on in the car, so I guess that's nice. The NBC affiliates have reported that people were shouting at Daughtry as she swam and there were fishing hooks and sharks in the water. She yelled that she didn't care and she wanted to get hooked and also wanted to meet sharks. Okay. All right. So people were like, there's fishing hooks in the water and there's sharks. And she's like, I'd like to get hooked by the fishing hooks and I want to meet the sharks. Okay. When deputies arrived, they said the woman swam away from the coast with no apparent intention of stopping. A local Marine unit eventually had to be called to bring her back. A staff member at Captain Khan's Fish House said they saw the woman and her son 3 times that week at the restaurant and she was acting odd. So apparently she was a repeat visitor to Captain Khan's Fish House. And the staff were like, this woman doesn't seem to be acting quite right. We called the sheriff's office. She didn't seem drunk. She didn't seem intoxicated. Something was just off. Apparently they were right. It's not that she's drunk. It's not she's intoxicated. She just seems to be acting a little strange. And staff members say they were primarily concerned over the young boy as he was young and still in diapers. They told the news that he was very well behaved and seemed oblivious to what's going on. If it were me in that situation, I'd want someone to take my baby in and make sure he's safe. Daughtery is currently charged with 1 count of child neglect for leaving the boy unattended in a car for 15 minutes so that she could meet her alligator and shark friends. Okay, that's fun. All right, let's wrap this up. Thus, that brings us to the end of story of Florida woman who apparently was a multi-time visitor at Captain Khan's Fish House in Lee County, and there's some water there, and she decided to get in and swim, abandoning her child as people scream at her about the fish hooks and the sharks, and she's like, I like the fish hooks and I like the sharks. And the police are up there and like, ma'am, could you please come to shore? And she's all like, nah, I want to swim. I can't be stopped. And they actually had to get a Marine unit out there to, arrest her. So, yeah. I don't think she's going to be welcomed back at Captain Khan's Fish House. I'm pretty sure she's going to be trespassed. Please don't ever come back. And not sure why she chose that moment to swim with the sharks, but she left her baby in diapers in the back seat, while she swam with the shark. Fortunately, the air conditioning was on, so I guess that's nice. And that brings us to the end of this discussion of this story. That is just a thing that happened. Baby shark do 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 do, baby shark do 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 do, baby shark. Yeah, I don't know if it was a baby shark thing or whatever, but it's like, okay. That's, 41, that's right at the beginning of millennials. I'm 42, I'm right at the beginning of millennials. Baby, January 1981. Respect. I'm an old ass millennial, baby. I'm an old ass millennial. God damn it, I'm old. All right. Drip Bayless sent their first super chat ever. Sending $1.99 this way, saying good morning and thank you for the stream. Tammy Ellison gifted 20 gift memberships. Nick S. gifted us SGD $20. We previously read that chat. Too High Strong gifted us 5 gift memberships. Too High Strong has also been a member for 4 months. And Sandy, our mod, has gifted 10 gift memberships. That's very, very kind, as always. Leon by the Sea also became an uncivilian by hitting that beautiful, beautiful join button. All right. So I'm going to send you redirect over to Laid Back News. I may or may not join. I honestly haven't decided, but I'll send you over that way to help support the channel at least. So I thought it was a good stream. I had fun. I thought it was a good stream. And I do appreciate every one of you who was here and on all the rest of it. So I got editing to do, and I'll get started with that. So until later, my friends, I hope all's well. Cheers, my friends, and goodbye.